got divorced, so I went to the University of San Francisco.
Noi vale mai noi kana hele. E ki puka ohui ka mauna I vale o Aliʻiōlani. I ke kui pua le yo helo me ole wahine I kana hele. O ke hoa li ke ole noia e kohu ole aina lani. Ma puganu o ka laua e I ka pali ma puno I ka pali o ia aloha. Aloha vale ke kapau ki palai no I ka uli le ole a I ka uka o ana kai. No vale mai no I ka le hua maka no I mo I ke a no atu vale I ke ala kui ma e ia ho o ka ia la o wa vale no e ia wa no na wa ke ala. Aloha.
Mahalo to Ahukini for that beautiful Oli tribute to Aliʻiōlani Hale, the home of the Hawaiʻi Supreme Court, and a beautiful welcome to all of you from the staff here at the Judiciary History Center. So mahalo Ahukini. Aloha mai kako and welcome again to Aliʻiōlani Hale, the home of the Supreme Court of the state of Hawaii. Prior to that, it was the seat of the Hawaiian Kingdom government. Thank you for joining us this evening to kick off our Honolulu Pride Month celebration. My name is Troy Andrade. I'm a member of the executive board of the King Kamehameha V Judiciary History Center. I'm a law professor at the William S. Richardson School of Law, where I direct the ʻulehua Scholars Program, and I get the great pleasure of moderating tonight's distinguished panel. We're gathered here tonight in the Supreme Court courtroom to reflect on a landmark legal decision made here in this very room over 30 years ago. In 1993, our Supreme Court became the first in the United States to recognize that same-sex couples have a constitutional right to marry in the landmark case Baehr versus Lewin. This ruling was a crucial milestone in advancing LGBTQ+ and Mahu rights here and sparked a global movement for marriage equality despite backlash in Hawaii and across the United States. We'll be discussing both the unique social, political, and legal, historical aspects that made this milestone possible, and now a reality in every state and 36 countries across this world. Speaking about this beautiful history and the challenges and opportunities we face ahead are our honorable and distinguished panelists. And so I'm going to give you a run through of these four amazing people so that when we capture this online on Zoom and it is forever archived on the web, people 50 years, 100 years from now will know who these people are and the significance that they've had. So our first panelist is Hawaiʻi Supreme Court Associate Justice Sabrina McKenna. Justice McKenna has served as an Associate Justice since March 2011 and is the first openly LGBTQ+ Asian American to serve on a state court of last resort. It's kind of a big deal. Justice McKenna graduated from the University of Hawaii at Manoa, where she played for the Rainbow Wahine basketball team as an early beneficiary of Title IX. She received her Juris Doctorate from the William S. Richardson School of Law, where she was editor-in-chief of the Law Review. Justice McKenna worked as a civil litigator, corporate counsel, and assistant professor of law at UH before becoming a state trial court judge in 1993. As a trial judge, she presided over civil, criminal, and family cases and served as senior judge of the Family Court of the First Circuit. Last year, she received the Margaret Brent Women Lawyers of Achievement Award, and in 2021, the Stonewall Award, both from the American Bar Association. She teaches state constitutional law at the law school, very popular class, and is also a Justice Pro Tem for the Supreme Court of the Commonwealth of the Northern Mariana Islands. Thank you for joining us, Justice McKenna.
Thank you.
Our next panelist is retired Associate Justice Stephen Levinson. Justice Levinson was an Associate Justice of the Hawaiʻi Supreme Court from 1992 to 2008, serving for 17 years. He was born and raised in Cincinnati, Ohio, and received his bachelor's in political science from Stanford University and his Juris Doctorate from the University of Michigan Law School. After law school, Justice Levinson moved to Honolulu to work as a law clerk at this very court. He then went into private practice at prominent Honolulu law firms for nearly 2 decades, until he was appointed a circuit court judge of the Hawaii First Circuit by Governor John Waihee in 1989. Justice Levinson has served on the board of directors of the American Civil Liberties Union of Hawaii and nonprofit organizations like Equality Hawaii, which advocated for the passage of same-sex marriage in 2013. Thank you, Justice Levinson, for joining us. Next, we have Associate Judge and Civil Rights Attorney Dan Foley. Judge Foley served as Associate Judge of the Hawaii Intermediate Court of Appeals from 2000 to 2016. He received a bachelor and Juris Doctorate degrees from the University of San Francisco. Since 1974, Judge Foley has had a diverse legal career as a litigator, negotiator, mediator, and judge. He was a prominent civil rights lawyer for almost 2 decades, including his time as legal director of the ACLU of Hawaii. Judge Foley also drafted the rules and regulations of the Hawaii Civil Rights Commission and taught civil rights litigation at Richardson Law School. Prior to his law practice in Hawaii, Judge Foley spent 8 years as legal counsel for different government entities in Micronesia, assisting with sovereignty efforts. He currently serves as a non-resident justice of the Palau Supreme Court. Thank you, Judge Foley, for joining us tonight. And finally, and not to be outdone, we have Dean Hamer, who joins us. Dean is the co-director of Lei Pua, ʻAla, Queer Histories of Hawaiʻi, a multi-dimensional project to document and commemorate Hawaii's history of gender and sexual diversity, and a curator of our new traveling exhibit downstairs, Kaulike no nā mea a pou, Toward Queer Justice in Hawaii. Dean is a graduate of Trinity College and Harvard Medical School, Scientist Emeritus at the National Institutes of Health, Emmy Award-winning filmmaker, and New York Times Book of the Year author known for his many contributions to our understanding of human sexuality and gender. He married Jo Wilson, in the back there, co-curator of the exhibit 20 years ago in Canada, before it was legal anywhere in the United States. Thank you, Dean, for joining us tonight. So following our discussion this evening, we're going to invite you downstairs, gather with us in the rotunda, talk story with us for the first look at our new exhibit, Kaulike no nā mea a pou, Toward Queer Justice in Hawaii, which again is a collaboration between Dean Hamer and Jo Wilson of Lei Pua, ʻAla, Queer Histories of Hawaii, and the King Kamehameha V Judiciary History Center's team. This traveling exhibit will be up I think for the next few months, and was made possible by a grant from the Mellon Foundation. And so on behalf of the Judiciary History Center, I also want to thank and mahalo nui the Hawaii Council for the Humanities for co-sponsoring the program for tonight. And of course, the team here at the Judiciary History Center, and Chief Justice Mark Rechtenwald, the Judiciary and the Legislature for providing space for us to reflect, honor, and celebrate our legal history. This is a monumental event in that I think this is the first time we're having a program to talk about these issues in this courtroom, in this space. And so I'm going to kick off our discussion. What I'm going to do is I'm going to ask each person one question, and then we'll do kind of a round table and get everybody talking. So I'm going to start with Judge Foley. You ready, Judge?
Yes.
Okay, first question. Here we go. Judge Foley, how did you become involved in gay civil rights in Hawaii, leading to your representation of the plaintiffs in Baehr versus Lewin? And if you could, what legal arguments were used to challenge the state's prohibitions at the time?
Yeah, I became involved with the LGBTQ community as legal director of the ACLU in the 1980s. I worked with them, Dr. David McEwen, Jack Law and others on HIV/AIDS issues, employment discrimination, and a case called the Miss Gay Molokai pageant, which is featured in the exhibit downstairs. And I'd worked with one of the more prominent gay activists, Bill Woods, and knew him well. A little rough around the edges, but got stuff done. So Bill organized 3 same-sex couples to go down to the Department of Health Services and apply for marriage licenses. They did in December of 1990. They were denied those licenses. They sought legal representation with the ACLU, the National Gay and Lesbian Task Force, Human Rights Campaign, Lambda Legal Education Defense Fund, and were turned away. So they had no organization behind them, no money, no lawyer. So Bill led them to my office in February to see if I would represent them. And I said, yeah. I told them I didn't think they had much of a chance. I'd never really thought of same-sex marriage before. There wasn't same-sex marriage in any state or any country in the world. The U.S. Supreme Court had said you can criminalize same-sex unions. There wasn't much to work from. But I had challenged the state pornography statute for the ACLU back in the 80s. And when I was doing my research of the 1978 Constitutional Convention that adopted the right to privacy, a committee report said this includes sexual orientation. So even though that was a different issue, I said, if I ever get a gay rights case, I at least have one document to be able to cite. And I remembered that case. So I agreed to look at it. I was teaching at the law school at the time. And so I said, if you withhold the license, what else do you withhold? What are the benefits and rights of marriage? So with my class, we went through the entire Hawaii revised statutes and identified hundreds of rights that were being withheld to same-sex couples that could only be accessed through a marriage license: health care, pensions, hospital visitation, wrongful death actions, real property, assignment of a gasoline franchise, a discount on a hunting license. There were hundreds. And so I put together a complaint for state court. I realized because of the U.S. Supreme Court in Baehr v. Hardwood, you couldn't go to federal court, and framed the case under the state constitution, the right to privacy, equal protection under the law. And doing it that way meant there would be no federal court review. Our Hawaii Supreme Court would have the final say. And our Hawaii Supreme Court had been more progressive when it came to individual rights, and to this day, but even then, back then, than the U.S. Supreme Court. In the pornography case, I'd actually argued before the court and succeeded to adopt the dissents of the U.S. Supreme Court, not the majority. And in the Baehr v. Hardwood case, there was a dissent of 4 justices saying sexual orientation came within the right to privacy under the federal constitution. So I put that all together and presented it to the lower court that rejected my arguments, and I appealed it to the Hawaii Supreme Court, where Justice Levinson was sitting.
Hey, that's a good transition. Okay, so Justice, so the case comes up to you, Justice Levinson, and the Hawaii Supreme Court. Tell me about what happened. What you're willing to share, what you could share with us.
As an aside, Dan and I had bumped or rubbed elbows before when we were both in private practice. We were on the opposite sides of the Save Sandy Beach Initiative Coalition case. My firm represented the Kaiser Hawaii Kai Development Corporation, and of course Dan represented the coalition, and it just so happened that we got along very, very well. And so that probably had some subliminal influence, at least, on the course of events once Baehr v. Lewin got going. But I think it's important to remember or think about how different the world was, at least in Hawaii, in 1990, when the three couples presented themselves at the Department of Health marriage license desk and were turned down from what it is now. Homosexuality was regarded by the American Psychological Association and the American Psychiatric Association as a mental illness. In fact, I was one course short of being a psychology major at Stanford. There was no psych course I wanted to take spring quarter of my senior year, and it wouldn't have found its way onto the diploma anyway because political science was already there. But I was able to take the behavior modification seminar that Professor Albert Bandura gave each year. And Albert Bandura was either the third or fourth most cited psychology academic in world history, only behind Sigmund Freud and maybe Watson and somebody else. So it's a big deal to take this course, and we had to write a big paper, and I cast around for a topic so I could strut my radical behavioral education, and decided, oh, a treatment program for homosexuality would be interesting. I still have that paper, still proud of it, at least academically. Got an A on it. Professor Bandura wrote, "Nice job," even though some of the procedures that I suggested following, in his view, would probably require police immunity. But in any event, I had that history. I had thought virtually not at all about the idea of same-sex marriage until the hearing on my appointment by Governor Waihee in the Senate Judiciary Committee. And toward the end of the hearing, the chair of the committee read to me a bunch of questions that had been either mailed in or phoned in or walked in 1992, no email, so that wasn't happening. And one of the questions happened to be, what is your opinion regarding the rights of gay and lesbian people to the equal protection of the law? I had thought about that exactly never. So I was quiet for about 15 seconds and I said, well, I believe in equal protection of the laws for everybody, including gay and lesbian people. And that was the end of that. I didn't know where the question came from, but where it came from in, I guess it was late March 1992, was someone who was following Baehr v. Lewin along, because it had already gone to the circuit court and the three plaintiff couples had been tossed out quite summarily. Failure to state a claim for which relief could be granted. And so, well, let me go back to the mindset, the paradigms of most straight people, including straight judges, in those days was quite traditional. The four courts that had considered same-sex marriage on appeal around the country ever all came to essentially the same conclusion, and that was, what's the equal protection problem here? By its very nature, marriage is intrinsically a union between a man and a woman. So if a man and a man want to marry, they can't, because that's not marriage. It's not in the nature of marriage. And the same with respect to women who want to marry. This guy, Professor Bernard Schwartz, in his book of legal lists that was published by Oxford University Press in 1997, listed in what were in his view the 10 greatest United States Supreme Court decisions, the 10 worst, the 10 greatest justices, the 10 worst, the 10 greatest non-Supreme Court, state court largely, opinions, and the 10 worst. And he listed Baehr v. Lewin, which had been out at that point for 4 years, as number 7, 8, among the 8. It was the 8th worst non-Supreme Court decision ever written. It was an example of what was in his view patent equal protection reductio ad absurdum analysis. The reasoning being, by its very nature, marriage is a union between a man and a woman. Therefore, there is no discrimination against same-sex couples with respect to access to marry, because by its very nature, it's a union between a man and a woman, and therefore there's no equal protection problem. It struck me as a little bit circular then, and it still does. But that was the state of thinking, generally speaking. And there was very little serious expression to the contrary as of 1992 when I joined the court. And so here was Baehr v. Lewin, which was on the calendar for oral argument about 4 months after I joined the court. And in those days, the way the court worked was a little different than it works now, and began to work not long after Baehr v. Lewin. The justices didn't talk among themselves about where they were coming from as to any upcoming oral argument until after the argument, when they all met in the Chief Justice's conference room and everybody weighed in with a position. That was the first, the other justices learned where everyone was coming from. And so a few days before the oral argument was scheduled to happen, I think in October 1992, I got a bench memo from one of my 2 law clerks, because that was the procedure. The law clerks essentially submitted to their judges memos analyzing the case, setting out the facts, the legal issues, the arguments, potential arguments anyway, what the parties had argued, and recommending a result. And lo and behold, her recommendation was to reverse the circuit court in the person of newly appointed Justice Robert Klein. Bob and I were old friends from clerkship days in 1972 and had joined the court at the same time. He couldn't be part of the court because he was the circuit court whose order tossing the 3 same-sex couples out was being appealed. And so it didn't take long to realize that appeals like this didn't fall out of the sky very often. In fact, this was very likely the proverbial big one. And I decided that I really wanted to write that opinion, assuming that there was a majority in favor of finding a right or a potential right of same-sex marriage at the state constitutional level. And it just so happened that the acting Chief Justice, Ron Moon, was my oldest professional friend, my big brother and role model and mentor. And he was the acting Chief Justice in this appeal because Chief Justice Herman Lum recused himself. He was set to be retiring not long after the oral argument was scheduled, and he may well have decided that he wasn't going to be around by the time the thing was going to come to a conclusion, and so he might as well step out of it. Justice James Wakatsuki had died in July of 1992, so he wasn't available. And Bob Klein was the judge who was being appealed from in the matter. And so he couldn't be part of the court hearing the appeal, which left Ron Moon and me, which meant that there had to be 3 other judges assigned on a temporary basis to this appeal. And so retired Justice Yoshimi Hayashi was one. I actually took over his office when I was sworn into the Supreme Court. I mean, his chamber, which Justice McKenna now has. It's a great chamber. I didn't have Justice McKenna's rainbow wahine varsity basketball jersey on my wall, but I had good things on my wall. Retired Justice Hayashi was a substitute. Chief Judge of the Intermediate Court of Appeals, James Burns, son of Jack Burns, the architect of the Democratic Revolution of 1954, was a temporary substitute. And Associate Intermediate Court of Appeals Judge Walter Heen was the third. So the panel that heard the Baehr v. Lewin appeal did not consist of 5 members of the court. Only 2 members of the court, the 2 newest among the 5 people who were hearing it, a retired justice who aged out before the opinions were ultimately filed. He had turned 70, and by state constitution, you couldn't sign an opinion after the age of 70, and so he couldn't sign. So there was an asterisk on the front page of the Baehr v. Lewin decision after his name, which at the bottom of the page indicated that he couldn't sign, see the provision of the Constitution, any opinion, but if he could, he wanted the world to know that he would have joined Judge Heen's dissent. So when oral argument began, I didn't know where anyone else was coming from, except maybe acting Chief Justice Moon, who I think I talked to some about it, but not very much. And I had a sense that I had a chance of being on the same side as he, at least to some degree, but I didn't know about anybody else. So imagine my surprise when almost right out of the box, I mean, after the Deputy Attorney General who argued the appeal on behalf of Health Director Lewin began talking and had gotten about 4 sentences out when the questions began, and Jimmy Burns said, well, do the marriage laws discriminate against same-sex couples? No, Your Honor, they don't. What do you mean they don't? It's in the exhibit downstairs, this quotation. Basically, the quotation is, a man and a woman come into the health department and ask for a marriage license application, they get. A man and a man come in and do the same, they don't get. A woman and a woman come into and ask for the same thing, they don't get either. That's discrimination, he said, as a declarative sentence. And I began to think, whoa, maybe we've got something going here. And so the oral argument concluded. Dan did an admirable job. Sonia Faust, the deputy attorney. Yeah. So in conference, I indicated that I was inclined to go with the plaintiffs on both equal protection and due process grounds. Acting Chief Justice Moon said, equal protection, yes. I think I'm inclined to go on equal protection ground, not due process, though, not right to privacy. Okay. Judge Burns said, well, I'm gonna go in favor of the plaintiffs on the basis that there are genuine issues of material fact here that need to be tried, that need to go to trial. Most notably, the nature-nurture question. Is homosexuality the product of learning history, or is it the product of hardwiring? Is it innate and in an individual? That seemed to matter for him. To him, it wasn't clear to me why that mattered any. And we talked about that in the opinion, but at least he was willing to go for the plaintiffs. And Judge Heen said, I know the Ali'i had their little boys. This is in conference. But that's not marriage, basically. And he went with the analysis of the four courts around the country that had considered the question earlier. And retired Justice Hayashi said, I'm a traditional kind of guy. This is without irony. I'm a traditional kind of guy. I'm with him, pointing to Walter Heen. And so Acting Chief Justice Moon assigned me provisionally the job of working up an opinion of the court. Judge Burns' comment about that's discrimination really created the grain of dust around which the snowflake formed, which created the snowfall and the avalanche. It occurred to me that this case wasn't really about gay marriage at all. I mean, by implication, by effect, it related to it. But the appeal came up to us before any discovery had been done. All we had, the record, consisted of Dan's complaint and the state's answer to the complaint and the state's motion for judgment on the pleadings and Judge Klein's order on the subject. And lo and behold, it turned out that nowhere in the Baehr v. Lewin complaint did Dan allege the sexual orientation of the plaintiffs. He didn't allege that they were gay. He alleged that they consisted of 2 male couples and 1 female couple. That was it. And lo and behold, the state constitution's equal protection clause said, no one shall be denied the equal protection of the law based on race or by virtue of race, ancestry, nationality. What's the other one?
Sex.
Sex. And of course, there had been a lot of debate by that time as to whether sexual orientation was subsumed within the term sex. As Dan indicated, the the Constitutional Convention of 1978, right, basically answered that question in a fairly obscure committee report, which they said, we didn't have to list sexual orientation in the new Equal Protection Clause because that falls within sex. Well, so I had that in the bag. And so I had to, if I was going to hold on to acting CJ Moon, by then CJ Moon, by the time it was all filed, I had to rule against the three couples on privacy grounds, due process grounds, and I wrote it up in a way that at least I could hold on to my lunch, you know. But on equal protection grounds, what we ruled was that on the face of the marriage laws, which clearly contemplated a man and a woman as the members of the union, by virtue of all the references to the husband and the wife and the use of pronouns all over the statutes, that was clear that this was denying access to the legal status of marriage on the basis of the sex of the applicant couples. And we even wrote in the opinion that for present purposes, it was irrelevant whether the plaintiffs or any of them were homosexual, because that fact wasn't before us. Nevertheless, Jimmy Burns concurred on the basis that this needs to go to trial and we have to answer the nature-nurture question. But that created essentially a 3-2 majority in the plaintiff's favor.
And so this was in 1993, right?
This was in 1993, and Judge Heen's dissent was along the traditional lines of, that's not marriage, so there's no equal protection problem.
Got it. So, Justice McKenna, at the time, you were a law professor, I think, when this came out. What was your reaction, if you would be so kind to share, and how did you teach this case to your law students?
Okay, well, I started practicing law in 1982. Justice Levinson talks about homosexuality being considered a mental disorder. That was when I was a senior in high school. Until December of 1973, it was considered a mental disorder. When I came to Hawaii, to UH in 74, and realized that I was gay, it was a very, very closeted time. I used to go to the Glades, hang out, but I was kind of like in denial with myself for many years. But like in 1982, I came out to my mom when I graduated from law school and became a lawyer, and she was from Japan, and she told me that I was no longer her daughter. That's the kind of time that it was. Things got much better as the years went on, and before she passed away in 1997. But it was a really different time. So I started teaching at the law school in 1991, and the trial court, Judge Klein, at the circuit court, had granted summary judgment. Well, it was a motion to dismiss for failure to state a claim, but he considered—
Well, it was motion for judgment on the pleadings.
On the pleadings, right. But there were additional things, right, in the record. So anyway, this is procedural, right? But I was saying, okay, this is really a motion for a summary judgment. Anyway, I was going to teach appellate advocacy in the spring to first-year law students, and I had like 20 students. And at that time, the law school let each of the professors choose their topic. So I said, this is a great topic for appellate advocacy. So I got the record from the trial court. I said, this is the complaint. This was the motion. These were the motions. Class, split yourselves up 10 and 10, and 10 of you write on behalf of the plaintiffs, 10 of you write on behalf of the defendants, and and then we'd had mock oral arguments like we were in the Hawaiʻi Supreme Court. So I did this in the spring of 92 and in the spring of 93. And lo and behold, I thought it might come out based on the genuine issues of material fact, the way Jimmy Burns ruled, because you see, Bobby Klein had ruled that there's no discrimination against gays and lesbians in Hawaii, so therefore there could be no invidious discrimination. I mean, he was basically saying there was no
powerless.
Yeah, they weren't politically powerless, and there's no discrimination. And I thought I didn't buy that argument candidly as a gay person, but in any event, the students argued it, and I will tell you that there were several students that argued it the correct way, that the way you guys came out on the Hawaii state constitutional grounds. So it was just amazing to me that this decision came out. And let me tell you, it wasn't just about the fact that, and this was not the first court in the United States to rule the constitutional grounds for marriage. This was the first court in the world, not just in the United States. No court in the world had recognized a constitutional right to same-sex marriage. So this was the first in the world. And, I hadn't really come out at work until 1991, when Hawaii became the third state in the country to pass an employment discrimination law. Based on, at that time, it was just for gays and lesbians. It didn't include gender identity and expression. Now it does. But still, without marriage, the possibility of marriage, and I was on the Gay and Lesbian Center, Community Center board, and there was a real, there was a lot of discussion within the gay and lesbian community here because we had gotten employment in 1991, and there was a lot of people that thought the approach should be incremental. We should go for like public accommodations, we should go for transportation, we should go for different things. But marriage was the whole shebang. And when the case was there and the ruling came out, it was like, oh my God, this is like everything. And because it means that it wasn't just marriage, it was our relationships could be celebrated and recognized. And that was a game changer. And I just remember crying, and I remember thinking, I really want to be a judge in this state judiciary. I really want to be a judge where the leaders, the Chief Justice and the Associate Justice, and let me tell you that the other thing is there was a motion for reconsideration. And by then, there was a new justice, the second woman. And I can't remember who she replaced, but she joined this was a plurality opinion at the beginning. This is technical, but 2 out of 5 on the equal protection. When she joined, it became a majority opinion of 3 on equal protection. I was like, 3 justices on this court are some of the most progressive justices in the entire world. I want to be a part of this judiciary, and I was so lucky that far I became Chief Justice Roberts' first appointee to the district court. So it was just a game changer for me. Thank you. To all of you, thank you.
So, Dean, maybe you can jump in and fill in some of the non-legal stuff, the cultural, social factors that were kind of unique to Hawaii that had an impact.
So as you've all heard, there were some very unique and probably irreproducible circumstances that allowed the decision to be made. But the decision was made in Hawaii, and it was accepted in Hawaii after a while in a way that probably would not be true almost any other place in the world. And that's because of different social factors and political factors and religious factors that have played out over the history of Hawaii. And that's what we start or try to address in the exhibition that you'll be seeing downstairs, is really to look at this over the span of time and to try to understand this across the many different populations and peoples and cultures that have come to Hawaii. And I think there are a couple of different factors that are really important. One is, of course, in Hawaii, there is a strong cultural foundation of acceptance and inclusion of what we now call gender and sexual diversity. And that was interesting, the comment you made about the ali'i and their little boys called aikane and mahu. And those were terms that people and practices that the missionaries tried very hard to get rid of. And they were successful in many ways, and there were lots of severe punishments. But just like the missionaries were against hula and tried everything to stop it, they couldn't really stop it, because people are people. And that was part of the culture here, and that was never really completely abolished. I think another strong factor is sort of women's power in leadership, which was very true in ancient Hawaii, but has continued so strongly today. You know, there's a reason why Hawaii was the first state to ratify the ERA. There's a reason why Hawaii was the first to have reproductive freedom. And those rights, of course, played a major role in the legal decisions that led to marriage. I think that there's also a strong tradition of civil rights in Hawaii because of colonization, because of all the labor disputes that the plantation life led to, because of the horrendous treatment of Japanese Americans during World War II. There has been a feeling in Hawaii that civil rights are really important and need to be protected. And so you have the rise to dominance of the Democratic or the large D party. You have the way that Hawaii has developed in many respects, where civil rights are really something that are very, very important. And lastly, there is, I think, an important religious factor. You know, if you look over history, even if you are spiritual and believe in religion, historically it has been the enemy of queer people. It's just been the real persecutors. But it's a little different in Hawaii. And one of the major reasons is that there's such a large Buddhist population here because of the immigration and the plantation labor. And Buddhists are really good on this stuff. I mean, they're not like pro-gay, they're just like pro-rights for everybody and peacefulness. And they're actually some of the biggest supporters of same-sex marriage in Hawaii. So when you take each of those factors separately, none of them by themselves is enough. You know, there are places with ancient traditions that are now amongst the most homophobic places in the world. And there are places with lots of Buddhists that aren't that great either. But you take all of those factors together in the unique mix that has made Hawaii, the unique mosaic. And I think it helped to create an atmosphere where this type of progressive treatment was possible. And I'm really grateful that that's the case. Yeah, so.
Mahalo. Judge Foley, tell me a little bit about the plaintiffs and sort of your work with them in this case.
What?
Sorry, the plaintiffs. Can you tell me a little bit more about the plaintiffs and your work with them?
I had never met the plaintiffs. There were 6, 2 female couples, 1 male couple. But this whole case had been put together by Bill Woods. He was head of the Gay and Lesbian Center. There may have been 2 of them, but it was all Bill Woods wherever he was. And he believed the statute didn't prohibit same-sex marriage, as it did. And so he was looking for couples and he found Joe Malilo and Pat Lagon, the 1 male couple, because Joe was very close to Bill. And Pat and Joe had a business and owned property together, and they said we'd like the legal rights. If we were married, we could protect our assets more. Then there was 1 female couple, Tammy and Tony, the only of the 3 couples that had a child, had a little girl. She later went to law school. And they wanted legal protections for her that they couldn't have if they weren't married. They were not active in the LGBTQ community in any way, but they heard Bill Woods' call and said, yeah, we'll sign up. And then the 3rd couple was Nania Baehr and Janora Dancel, and they were lovers, and one got an earache and the other one had the medical coverage, and it couldn't cover. So when they heard the call from Bill Woods, they figured, oh, if we can get medical coverage, that would be great. And those are the three that he paraded into my office. The only activist of the six was Baehr. She ran the Women's Center up at UH across the street, and was a very aggressive feminist. It published, was familiar with doing media appearances. So that's why I put her first when I drafted the complaint, Baehr v. Lewin, because I realized that the six, she would be the best spokesperson, which she turned out to be. Once the case progressed, Tammy and Tony showed up for my trial before Judge Chang in September of '96, but otherwise disappeared, then moved to Nevada, and then married in Nevada when Nevada legalized it. Nania and Janora moved to the mainland and split and spent their time with Lambda Legal Education Defense Fund raising money for them. And Pat and Joe stuck with us the whole time. The sad thing is I married Janora and a new partner in December 17, 2013 in this courtroom. Nania married someone else. Tammy and Tony were the only two that remained together and married. And unfortunately, before 2013, when Hawaii finally legalized gay marriage, Joe Malilo died of cancer. So he and Pat were never able to marry.
So we have this groundbreaking decision in 1993. Anybody want to pick up on what happens after that in Hawaii in terms of the political, legal context around marriage?
I'll start with that. We got hit in the face, really knocked down. I was under the impression that Hawaii was more accepting and progressive for the reasons Dean outlined. So I figured once the decision came out, people will see there's no harm, only same-sex couples and their families benefit. But there was just an extreme adverse reaction funded by the Mormon Church. They spent over $1 million in this. And the evangelical churches, the Catholic churches, politicians, because 70% was against us, and politicians line up where public opinion is. So immediately the chair of the House Judiciary Committee, Terrence Tom, started holding public hearings to galvanize this opposition. And in the '94 session, the first session after Justice Levinson's opinion, he introduced a bill to ban same-sex marriage. So we figured, how do we stop that? And we were getting organized. The LGBTQ community finally started coming on board, the civil rights community, women's groups, etc. And we figured the best way to get the legislature to do nothing is to have them study something. So we proposed a commission on sexual orientation in the law to study the matter and make recommendations, which went on for 2 years. So they didn't pass anything in the '94 session other than a statute saying, the statute means what it says, same-sex couples can't marry, but that didn't mean anything because under the Constitution they could, under Levinson's opinion. And then finally the commission chaired by Tom Gill, former lieutenant governor, congressman, recommended to the '96 session that the legislature legalize gay marriage. They couldn't find any good reason why they shouldn't, couldn't find any harm coming from it, only good. Legislature didn't do that. They said in the alternative, legalize domestic partnership with civil unions, everything but the name. They didn't do that either, but they didn't do anything, which is all I wanted. Don't do anything. So we went to trial before Judge Chang in September of '96. He issued his order in December of '96 that the couples have the right to marry. There's no good reason not. Issued an order, but stayed it pending appeal. Unfortunately, the November before his decision, after trial, 5 legislators that had stood with us and stopped the constitutional amendment were targeted. by the churches and by activist groups. They're the ones that are pushing gay marriage on all of you. Let's vote them out of office. And 5 were voted out that otherwise would not have been voted out. So the rest of the legislators lost their nerve. I got a call right after the vote came in from Matt Matsunaga, who was in the Senate, and a friend. The Senate Judiciary Chair was voted out, Ray Gralty, who had stood with us. And Matt said, we can't hold anymore. You know, it's going to pass this session. That was the 97 session. And so they felt so guilty. They put together a bill called the Reciprocal Beneficiary Act, because they didn't want to say civil union or domestic partnership, and passed that. It was the most progressive piece of legislation for same-sex couples other than Denmark, which had done something similar in 1989. And then they passed a bill that didn't prohibit same-sex marriage. The bill that was to amend the Constitution as originally written was to ban same-sex marriage. Marriage is between a man and a woman. But our friends in the Senate, with our encouragement, watered it down a bit to basically say the legislature has the power, you know, to reserve marriage to opposite-sex couples. So that meant that if the legislature banned it, which they did, they could ultimately change their mind. Well, the Constitution Amendment was overwhelmingly passed by 69% of the vote, November of '98. But one of the things I did after Justice Levinson's decision came in, Lambda Legal Education Defense Fund saw this case, as Justice McKenna described it, as really important, where they had rejected it before. So they wanted to come in after the decision. The couple said, no, we don't want you. We went to you, you said no. And I said, do you have money for the depositions? Do you have money for the experts? Lambda will underwrite the rest. Then they said, yes, they can come in. But one of the important parts was we knew that with Justice Levinson's decision, given the full faith and credit clause, people would come to Hawaii, marriage, go back to their homes to get it recognized. And me, as the straight guy from Hawaii, I was not going to be leading the national gay and lesbian, movement. I needed somebody from the inside with money, organization, power. That was Evan Wilson. So he came in as co-counsel and basically took it national to Vermont, Massachusetts, and whatnot. And that worked. So ultimately, by 2013, 14 states had already legalized gay marriage through courts or legislature. Public opinion had ultimately changed from 70% against to a majority for. The U.S. Supreme Court in 2013 had declared unconstitutional part of the Defense of Marriage Act, which was enacted by the U.S. Congress rejecting marriages out of Hawaii. Then, once there were 14 states, once the U.S. Supreme Court rejected part of the Defense of Marriage Act, once public opinion supported same-sex marriage, once Barack Obama and Joe Biden supported same-sex marriage, then our legislature said, oh, we'll change our mind, and legalized it in 2013.
Could I just interject one thing? I think it's important to understand how fragile the conditions were that resulted in the Baehr v. Lewin decision. I have no doubt that had the matter come to the Hawaiʻi Supreme Court 4 months earlier, the plaintiffs would have lost probably 5-0, maybe 4-1. Maybe Ron Moon would have dissented. But as far as I could tell, Herman Lum, James Wakatsuki, Yoshimi Hayashi, all 5 of the members of the court as of 4 months before, with the possible exception of Ron Moon, being traditional kind of guys, I mean, very fair-minded, but same-sex marriage, I think, for them was just unthinkable. It wasn't marriage, as the other courts had said. What was different about me Well, the couple of things I can think of. One, I was younger, and therefore I was basically of the next generation for what that's worth. You know, a baby boomer. I was one of the first baby boomers, being born in June of 1946. But it also so happened that from a very young age, I had been obsessed with the idea of marriage. In fact, I had a running daydream as a young kid that involved being married at that age. And my feeling for myself was, well, why not? I kind of had a sense of what marriage was all about, I thought, as an 8-year-old kid. Why not? And so I think that probably made it easier for me to conclude, having read the briefs on both sides of the issue when it came before the court, well, why not? And I think the other guys could not have gotten even to why not. Well, here's why not. What do you mean? Marriage? Them? Cannot. That's not marriage. But for this confluence of circumstances at exactly the right time, Baehr v. Lewin would have gone the same way as all the other judicial attempts to bring same-sex marriage about had gone. You lose.
Yeah, and I think Judge Foley kind of wrapped in the way in which Hawaii as a community still wasn't okay with that decision, right? And it took 2 decades more for that to kind of really come to fruition.
And it certainly was not okay with the Catholic Church and the Mormon Church and the evangelicals.
Mm-hmm. Mm-hmm. So let me ask this question. We talked a little bit about the state side of things. Maybe someone can jump in on the federal side and what was happening across the country in terms of the Obergefell case and what influence potentially the Baehr case had on Obergefell.
Well, it was my co-counsel on the case, Evan Wolfson, put together a group called Freedom to Marry. And what he did was he began coordinating what was going on. He was co-counsel in Vermont, where they went civil unions, co-counsel in Massachusetts, first gay marriage, and then the other states. So it was coordinated, looking for the states that were the most progressive in terms of judges, or in the legislature. New York was the first to do it by legislation. So he put together a campaign. It was like with miscegenation laws, the first state, California, to overturn a marriage between a Haole and a Filipino. It took 20 years, state by state, where there was like 3/4 of the states that allowed interracial marriage before the U.S. Supreme Court would do it. And that was basically the strategy, state by state, and ultimately build the momentum, change public opinion. And the other thing that worked was that in 2003, the U.S. Supreme Court overturned Bowers v. Hardwick in the case Lawrence v. Texas. So all of a sudden, then the federal courts were open, were litigation. So you had litigation in the state courts, the federal courts, you had initiatives, and you had legislation. And it was all coordinated, building towards the 2013, which was when the U.S. Supreme Court said the federal government cannot reject same-sex marriage. And when you read that opinion, it was clear the other shoe was going to fall, which 2 years later, 2015, states cannot reject it either. And then finally, in December of 2022, the Respect for Marriage Act passed, signed by Joe Biden, which repealed the Defense of Marriage Act and said the federal government recognizes same-sex marriage and states must do so as well.
Just to add to the history of that, at the same time, social attitudes were changing very rapidly. And at least some of the people here in Hawaii have said that part of that was because of the AIDS crisis, that was the first time that a lot of people had to come out because they were sick, and the first time that a lot of allies felt compelled to support people because it was so serious. So that was a factor. And then there was a real shift in opinion, which sociologists still do not understand. But in 1991, we actually have polling data in Hawaii, which is unusual. There were 70% of people who were against marriage, but there were 70% of people who were for the anti-discrimination law. So it wasn't like everybody was anti-gay. It was more like, well, we're great with gay people. And everyone says, and I have a mahu in the family, et cetera. But marriage is like, oh, that's, no one had even heard about that. But by 2003, 2004, there had been a dramatic shift. And a majority of people now started supporting same-sex marriage. And nobody really knows it's because they just knew more gay people, or they'd seen a few married couples, or they had gotten used to the idea that, hey, if you're going to be a full citizen, marriage is part of that. Or if it was because of all the great advertisements with the happy families and, the two lesbian moms and the nice kids and everything and, strolling in the park. But there was a really dramatic shift in the general population as well.
I should note that in Baehr v. Lewin, in the decision, we suggested that the approach to same-sex marriage on the basis that no equal protection problem, because that's not marriage, so what's the discrimination, was exactly the same as the matter of interracial marriage. The United States Supreme Court decision that struck down anti-miscegenation laws in that instance in Virginia, we cited as an example the Loving case, Loving v. Virginia. And it turns out that the trial judge in Virginia who sentenced the Lovings to a jail term for holding themselves out as being married in the Commonwealth of Virginia said this, as he sentenced them: Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix. Substitute sex for race, and you have the same reasoning. There's no discrimination here. There's no equal protection problem because that's not marriage. You can't get married anyway.
So Justice McKenna, kind of given this conversation we've had, we've talked about, gotten some really interesting details about the decision-making process for the Baehr decision, the context in which this decision was made. How can understanding this history inform current advocacy efforts for the LGBTQ, the Mahu community rights and the rights and equality?
Very good question. I think that, as you know, things have, in Hawaii, we are one of the more progressive states in terms of anti-discrimination laws, but as you probably know, actually, I was thinking as we were talking about this, one thing that we didn't talk about was, what was her name, Phyllis Schlafly, and the entire the conservative movement, the anti-gay movement that was really happening more from the southern states, and the conservatives really used gay issues, family values, to try to rally their bases to get votes, right, in terms of politically. And now they're doing the same thing with the transgender community. That's what they're doing. All of the laws for the transgender athletes, right? And now there's, there was some state that is trying to find the records of the medical records of a teenager to ascertain whether the teenager is biologically XX or XY. I mean, that's really what we're getting to, right? So in terms of the transgender athlete bans and things like that, so I think that it's just like in Baehr versus Lewin and Evan Wolfson, and how the state by state approach, whether it was anti-miscegenation or same-sex marriage, and as RBG was heard to say that Roe versus Wade, they didn't wait long enough, right? That if more states had jumped on in terms of abortion rights, maybe there wouldn't have been as strong as a backlash. So I do think it is the state by state approach, but as a practical matter, we have Bostock that recognizes that gender identity and sexual gender identity and expression are covered by Title VII, right? In terms of those are sex-based discrimination. So we have so many sex-based discrimination federal laws on the books right now. So it seems to me that those should be applied, whether it's in Title VII or Title IX or other, but Title IX, there are some exceptions now in any event. But I do think that it is an awareness issue. It's an education issue. And I think I came out publicly, like in 2011 when I was appointed to this position, because I thought my last position was in family court, and I realized that despite things getting better, there was, LGBTQ youth are 4 times as likely to attempt suicide, and then LGBTQ youth that come from families that reject them are 8 times as likely to attempt suicide as youth that come from families that accept them. And then there were some studies that showed that whereas close to 80% of white youth come out to their parents, it goes down to about 50% for Asian and Pacific Americans. And that's because the kids know what their parents think about LGBTQ issues. You're growing up in these families. And just like my mom said, you're not my daughter, she later came to accept me. And, the reality is like, especially like Asian immigrant groups, and the Asians have the highest immigrant, and which countries do not recognize same-sex marriage still. Now, finally, Taiwan and Thailand, and it's expanding, but still like Japan and China, India, right? Oh, but the newest upcoming prime minister has written and spoken in favor of same-sex marriage. So I'm hopeful for Japan, but in any event, we'll see. But I do think that it is a personal issue, and I think it's important for people to, and it's coming out as a personal choice. It's a completely personal choice. And that's why I was completely opposed to, like, what is it, ACT UP? The people that would try to, out people. I don't think that's right, because you don't know what the people are going through. You don't know what ramifications they might have. But I think it's really good when people come out and then people recognize that, hey, to me, it was important to come out so that people could see that, hey, you can, I have, unfortunately, my partner and I didn't work out, but we still get along. We have 3 beautiful children, and it's, you can have a happy family, and you can have professional success, and you can have a great life. And I think it's important for people to see that.
Thank you. So as we're kind of wrapping up, I guess, one big outstanding question, and you touched on this a little bit, Justice McKenna, but for maybe anyone else, do you feel like marriage equality in Hawaii right now is sort of ironclad? Or are there things that could be done, things that we need to be cognizant of or watch out for?
Well, yeah, that brings us to the matter of the proposed amendment to the state constitution, which is on the ballot this November. That notwithstanding the evolution of the fate of same-sex marriage in Hawaii and around the country, the 1997 state constitutional amendment is still on the books, which says that the legislature shall have the power to reserve marriage to opposite-sex couples. As long as Obergefell remains the law of the land at the federal level, that has no force and effect. But if the United States Supreme Court were to take Obergefell back, then the state of the law would include the legislature shall have the power to restrict or reserve marriage to opposite-sex couples. So what the proposed amendment does is repeal that, which makes the state of the law in Hawaii, or would make the state of the law in Hawaii regarding same-sex marriage, Baehr v. Lewin again. And as long as Article 1, Section 23 of the state constitution is repealed by this new amendment, my feeling is that same-sex marriage is safe in Hawaii. But it's very, 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 very important for that new amendment to pass. It takes a majority voting yes of all of the ballots cast, which includes blank ballots. So for purposes of the amendment, a blank ballot is the same as a no. So it's absolutely critical that this amendment pass. And at that point, I think it's ironclad.
So yes on marriage is what you're saying.
Yes on marriage.
Yeah, that's
Yes on question 1.
I'm going to end this by maybe, Dean, talking to you a little bit and asking for your thoughts about this new exhibit we got downstairs. And any insights you want to share with us? Or
just we're very excited. Lei Pua ʻAla Queer History Project is trying to bring alive stories of our queer past and to really mark those on the landscape. And our basic idea is that wherever history is told, queer history should be told along with it. And so we're very happy to be bringing this exhibition here. It goes from ancient days up to the present. There's a lot of interesting anecdotes, like 2 plantation workers trying to get married in the 1920s, or 2 legendary Hawaiian chiefs getting married back in the 1400s. So I hope you'll check it out, and I hope you tell your friends, and we're looking forward to sharing it with you.
It's a great exhibit. I've reviewed it. It's great. Please take a look.
so let's close with some final thoughts. We'll go right down the line. Maybe we'll start with Dean and work our way back this way. Any final thoughts for our guests here tonight?
Just to say that, things can change a lot. I started this work 50 years ago where I could be thrown in jail for being who I was. It's amazing to come to Hawaii where things are so different. But it's also studying this history, looking at all the pain and suffering over the last decades and centuries. It's important to realize that things can change too. And so this is sort of a never-ending battle, and it's wonderful to be part of the fight. Yeah.
Well, I just feel privileged to have been part of a case of a lifetime. That what Hawaii did, and there's many people in this room that I recognize that were with me, that we in 25 years went from no states and no country to all 50 states and now 39 countries and counting, recognizing marriage equality. And it was you that did it. So if we can do that, we can do a lot of things. Thank you.
It's occurred to me that the evolution of same-sex marriage, or the recognition of it, is, I hope this isn't too grandiose a thought, sort of like before moment X, there's no life in the universe. And then after moment X, there is. And how did that happen? And it seems to me that, but for the fact that everything was just in the right place when Dan filed his lawsuit on behalf of the three couples, that it resulted in the creation of life in the universe. If I'm not so sure, I'm not so sure that the Hawaiian matrix, at least in the first instance, had all that much to do with it. Witness the fact that had the matter come up for decision 4 months earlier, it would have gone the other way. But something happened and it all came together. And there are very few people on this earth who can say, you know, I was a part of this cosmic change. I just happened to be in the right place at the right time, and I'm extraordinarily grateful for that. So when my daughter finally came out a year and a half after Baehr v. Lewin was filed, by way of a question that took her 2 minutes to ask, but the transcript of which reads, "What would you say if or think if I told you that I'm more attracted to women than I am men?" I could say, "See, that wasn't so hard, was it?" And that's what happens when there is a fundamental paradigm shift that's kind of unexplainable, but other than that, everything was there to make it happen at the right time. So we're all very, very lucky kids, it seems to me.
And I'm still a member of this judiciary, so I'm still a judge. So I'll comment more from the perspective of judiciaries and with people that are here. As Justice Levinson has said, it makes a difference who's on the bench. And if it hadn't been for him and CJ Moon, we might not have had this wonderful decision. So I would just say that I totally disagree with Chief Justice Roberts when he says that judges are umpires and we call balls and strikes. Judges are human and we come with our own perspectives. So I'm going to ask that as members of the community, please care about who our judges are. Please watch. And the other thing is, 38 states have elected judges, and once in a while, the legislature tries to put out a constitutional amendment suggesting that judges should also be elected here. Judges should not be ruling just for the majority, all right? So please never vote in favor of electing judges. You want judges that are independent.
I think we could probably go on for hours with this crew over here. But that brings us to the close of our program for this evening. We welcome you to join us downstairs for some refreshment and interaction with the folks here. Thank you so much for joining us tonight. And I hope you had a wonderful time. Please once again join me in thanking our great esteemed panel.